Welcome to Revolutionize Your Retirement Radio, bringing you insights and strategies to help you create a magnificent and fulfilling second half of life. Here's your host, certified professional retirement coach and best-selling author, Dr. Dorian Mintzer.
I want to welcome everybody to my fourth Tuesday Revolutionize Your Retirement Interview with Expert series to help you create a fulfilling second half of life. I'm Dorian Mintzer, your host and owner of Revolutionize Retirement, and I'm delighted you're all here with us today. So anyway, without further ado, I want to introduce our wonderful guest today, Harry S. Margolis. He has been representing seniors, individuals with special needs, and their families since he started Elder Law Services, the predecessor of his current firm, which is Margolis and Bloom. And he started his Elder Law Services in June 1987. Since then, he and the firm as a whole have helped thousands of clients pay for long-term care, grapple with the incapacity of a family member, and plan for safe and productive futures for their children and grandchildren. Harry served as editor of the Elder Law Review, a monthly newsletter for attorneys. For 3 decades, he's been editor of that. His leadership in the field has been recognized by his peers in his selection as a fellow of both the National Academy of Elder Law Attorneys and the American College of Trust and Estate Counsel. He's been named a super lawyer since 2005 and in different years recognized as one of the top 100 attorneys in New England. In 2015, Best Lawyers named him Best Lawyer in America in the practice of elder law and trust and estates, and he's the only elder law attorney to receive these honors. He strongly believes that the best legal solutions are achieved through the partnership of well-informed clients and attorneys who combine great technical expertise, experience, and an ability to listen. Most recently, he began answering consumer questions online at www.askharry.info. And he's also the author of Get Your Ducks in a Row, The Baby Boomer's Guide to Estate Planning. And there is a new edition that just came out in 2020. I have actually the one from 2019. When not working, Harry resides in Brookline with his wife, college-age twins when they're home, and a dog of uncertain breed. He loves biking and traveling both in the U.S. and abroad. And Harry and I both live in the same community and have met both professionally as well as just personally at times through town meetings and things like that. And I mentioned, and I want to mention to all of you, I really have found Harry's book really helpful. And, you know, those of us in the boomers population, the oldest of us, the leading edge ones, of which I am one, are all turning 75 this year. And as Harry had put in his program description, that if you haven't kind of already, 75 needs to be the time that you do all this estate planning. And I was telling him that at least in the 2019 edition, I really love it, that it's a really big print. And it's very clear and helpful and concise, so I do recommend that people get the book. So anyway, Harry, without further ado, welcome. And, you know, maybe we could start out, what motivated you to write this book?
Thank you, Dory, for the introduction and for that. Just a few things. I've been, as you mentioned, working with clients for over 3 decades now, and I think there are sort of a few things. One, I've been trying to explain the same issues and answer the same questions for a lot of that time, and so I thought, well, it might be easier just to write everything down so that people have it and it's available and make it more easily available to people. So that's part of it. And part of it just getting to this point in my career, kind of interested in taking what knowledge I've gained over all that time and just making it available to people. So fortunately, my kids, as you mentioned, they're actually out of college now, so I don't have that financial burden, and I can spend more time, in effect, giving stuff away for free. So without having to make a living and the same burden to do that. So it's more fun to answer questions and not have to charge for it.
That sounds great. Probably people like that a lot too. One housekeeping event Don, I just want to hear from you for one moment. One question is that the broadcast is interrupting constantly, and the person wonders if she's the only one. I'm hearing everything quite fine but if others of you are having this problem, if you would put it in the question, and if I don't hear from others, Greta, the person who wrote the question, now she's calling from another country also, and that may be part of it, but it might be, we get people, mostly this country, but we have people from around the world who come to this. So unless I say something differently, Greta, it may be that you just, maybe call back in or something, if you could try that and see if that might help. Or Donna, do you have any other thought?
And it might be her internet connection as well.
It might be the internet connection. Okay, so, all right, I haven't gotten anything from anybody else having problems with it. So, but anyway, okay, back to you, Harry. Yeah, a couple of people have written that they're not having any issues with the broadcast.
Oh, good.
So some seems like it's unique to Greta, who's calling from Portugal. So, what is estate planning? You talk about it in your book, and I think that may be a good place to start, and then we can get into some of the specifics.
Yeah, that's a great question, and estate planning is a terrible name for what we do, because when people think about it, no one thinks they have an estate. An estate is a mansion with a huge green lawn and walls around it or fence around it, and none of us has that, right? So, but that's not what lawyers think of when they think of an estate. Basically, an estate is whatever you own. So if you own a house, that's part of your estate. If you have a stamp collection, that's part of your estate. Whatever you have in the bank or in retirement plans or in investments, that's all your estate. And estate planning, there's really two sides of it. So one side is planning for what happens to it when you're gone. Who does it go to, and does it go with strings attached or just outright for people to do what they want with whatever they inherit? But the other side of it, which is at least as important as what happens after you're gone, is what happens while you're alive. Mm-hmm. So, and this is especially the case if you lose capacity in some way, or if, in terms of elder law, if you start facing really high expenses for living and care needs you might have. So a big part of estate planning and the kind of the tagline we have on our website for our law firm is planning for life. So it's not just planning for death. So putting structures and people in place to manage your assets, your so-called estate, and make healthcare and life decisions for you if and when you're not able to do that yourself.
Great. That's a really clear explanation. And so with that, it sounds, and you also reiterated in the book that no matter how much or how little assets you have, it's important to think about how you want to manage it so that it doesn't just, get decided for you.
So it doesn't get decided for you and the decisions aren't made that you wouldn't want, but also so that there's clarity for family who's going to make decisions so that they're not either one side fighting about it or the other side just trying to kind of pick up the pieces and with no one having any guidance on who's supposed to do what.
Yeah, good clarification. So what are some of the barriers that get in? So why do people put it off? I mean, particularly, I'm just sort of thinking of the impact of COVID that we're just sort of seeing, we always know we don't have control over sort of life and death, but it's even more apparent right now. But so what are some of the things you've discovered over the years that excuses people make to avoid it?
I think there are a whole bunch of barriers. One of them is just lawyers ourselves. Lawyers can seem a little off-putting and scary and expensive, and so people often just don't want to deal with lawyers if they don't have to. And now there are a lot of online programs, some of which are pretty good in terms of getting your basic documents done, but they're not good at answering questions if your situation isn't straightforward. So that's one. So the lawyers themselves and the cost. I think that's part of it. The other part is people are thinking about things you don't want to think about, your death or your disability. I mean, who wants to? That's not going to make your day thinking about those things. So you tend to put it off. So I think that's part of it. For some people, making decisions can be difficult. If you're trying to choose who's going to be your healthcare agent or who's going to be on your power of attorney or who's going to be the executive of your estate among your children, and you're afraid somebody's going to feel insulted if you don't appoint them, well, then you might not appoint anybody because you may just kind of put it off. And then finally, it's not on the top of your list of things you have to do. Life can be busy, and this is something you got to get done, but the odds, at least until you're in your 60s, 70s, 80s, the odds are pretty good that you're not going to need it tomorrow. So you deal with what you got to deal with this day, this week, this month, not something that's really for the future. So I think those are the main reasons.
Helpful. I can attest, just knowing for our family, having an estate plan, it feels like a liberation. Just because, you kind of can put it away, although it is true. I know we're kind of re-looking at ours now, that when we first wrote it was when our son was younger, and now he's out of college and older, and so we're actually in the process of revisiting it. Do you find that a lot with people, that people maybe do it at one stage and sort of forget to get back to it at another stage?
Yeah, I think that's absolutely typical, and not really the end of the world either. So in most cases, people often do it when they have a child, because they know now they have someone they have to take care of, and the most important part of that is really naming a guardian in case they're not around to raise the child. So they kind of do the responsible thing, get the estate plan done, and then they might not look at it for another 30 or 40 years. So the next time might be when they're thinking about retirement, and then presumably they also have a lot more assets than they might have had when they were young and having their first child, so that there may be a lot more that needs to be done, and things have changed. You no longer need a guardian for the child. The child himself or herself might be the person you're going to appoint on the documents. So I don't think that's really the end of the world if you do it when you're young and first have a child, and then do it again when you're at retirement age, unless there's been some change. So if something's occurred, if somebody who's significant to the plan passes away or becomes disabled, or if you got divorced, or if you get remarried, or if you're in a new relationship, any kind of change may mean that you need to update the plan. Or if you move from one state to another, or from one country to another, it sounds like from the people on the call, it may be time to have a review. But absent a significant change in your situation, it might be fine to do it in your 20s or 30s, and then again in your 50s or 60s. So at least for most people.
So I'm going to just integrate things from some of the listeners as you're talking, if that relates to it. And Odette from Georgia wonders, can you update your estate planning documents like power of attorney and, health care proxy, living will, all of those? If your wishes are the same, she asks, can you just simply change the date and initialize them, or do you have to kind of do a whole new review?
Well, it's worth doing a review, but if there's no need for change, you might not need to make a change. So if you're still appointing the same person on your healthcare proxy or your power of attorney, it may be fine, though it may be fine legally, but on the power of attorney, there's a kind of a non-legal sort of situation, which argues for updating it more often. Because the problem is that some banks and financial institutions are reluctant to accept powers of attorney because they're afraid that the person who's the agent is somehow defrauding the principal, the person who signed and granted the power of attorney. And they actually have a perverse response, which is they'll accept a newer power of attorney but not an older one. And the reason I think that's perverse is presumably if you're 40 years old and you name someone in your power of attorney, you were totally competent when you did it. But if you're 80 years old and you've done it just a few years or a few months before the person starts to use it because you've now become incapacitated, maybe you weren't so competent when you signed that power of attorney. But they seem to accept that newer one more than the older one. The other thing I'd say with powers of attorney is that a number of financial institutions, again, banks or investment houses such as Fidelity or Charles Schwab, have their own forms for powers of attorney. So if you have an account, wherever you have an account, I would say ask them if they do, and if they do, execute their durable power of attorney as well as the general durable power of attorney for all purposes. And that will make it more likely to be accepted by the institution when the time comes.
Well, that sounds like very important advice. Maybe, and I think this question from Odette sort of raises it. I mean, it's possible that everybody on the call knows this, but maybe it would be helpful if you could just say what are the kind of estate planning documents that are the most important for people to be aware of?
Yeah, that's another good question. So I'm going to rank these in order of what I think is order of importance. So the most important is the durable power of attorney. So that appoints somebody who you choose to handle your finances and your legal matters if you become incapacitated. And that can be really important because otherwise, if you do become incapacitated, nobody's there to kind of pick up the pieces, to pay your bills, to make decisions, to sign any documents that might need to be signed. And the result may be that family members have to go to court and get appointed conservator or guardian, which is problematic in a number of ways. It takes time. There's delay. It's more work for people right when they're already probably busy dealing with your illness, and it's expensive. So if you can avoid all that with a power of attorney, that's the thing to do. Then the next most important document is the healthcare proxy or power of attorney for healthcare. Different states have different kinds of documents for this, but they're pretty much the same. And there you appoint an agent to make healthcare decisions for you. And that's also incredibly important if you're not able to. Some states have sort of a list of people who can step in if there is no agent. So it may say, well, if there's no healthcare agent on a power of attorney or proxy, that your spouse or your child or your parent can step in order of precedence. But that can be problematic if there's disagreements between people at the same kind of level of priority. And not all states have that. So in my state of Massachusetts, if you don't have an agent, you don't have anybody. And again, your family may well have to go to court to get somebody appointed. So that's number two. And then number three is some kind of healthcare directive. So this could be part of the healthcare proxy or separate document. But very often you appoint somebody as your agent and they have no idea what you would want in a particular situation. So you may want to say whether you want, if you're, say, in a coma or a vegetative state, whether you want all life support withdrawn. Get more or less specific on this guidance. And there are a number of workbooks out there, actually, you can get online if you want to get more specific in providing guidance to your agent. But at least have a discussion or write a document that gives guidance so they know so that they can do what you would want them to do, which is really their job. And then the fourth most important document is the will. You might see, and you might be surprised that comes number 4, but it's actually, I think, diminishing importance over time for a number of reasons. One is that a lot of people have designated beneficiaries on their accounts in any case. So if you have a retirement plan, you've designated a beneficiary. If you have a bank account, you may have a joint owner. If you have an investment account, they may allow you to name who will inherit it. And so a lot of property at death passes without going through probate, which in the will only governs what's in probate. And so the will governs less and less property, I think, all the time. But still important to have for a number of reasons. First, it allows you to appoint somebody who's in charge. They're called either personal representative or an executor or an executrix. And you need somebody who's going to manage the process after you pass away. So that's the most important reason to have a will. And the other reason is you may have property doesn't have a designated beneficiary, so that has to be governed with the will. And then finally, you just need a property, and you need a mechanism to pass property in case things kind of fall through. You may have thought you've named everybody as beneficiaries in all of your accounts, but it may be that there's an account that you haven't named somebody, so you need to say that in your will. So the will comes in fourth. And then finally, I've become over the years a great proponent of revocable trusts. And a trust,
of what? Say it. Trust.
Revocable,
okay.
revocable or revocable trust, both pronunciations is fine. And they do a lot of different things. So while you're alive and you have a revocable trust, it governs whatever assets you put into it. And you can name a co-trustee or successor trustee who can step in, again, upon your incapacity to handle your finances, and it often works better than a power of attorney. So that's one reason I'm in favor of them. And you can have it's not either or. If you have a co-trustee, you can continue to manage everything as long as you can, but the co-trustee is already there to step in seamlessly because they're already on the accounts. With a power of attorney, once the person who's appointed needs to step in, they need to go to all your financial institutions, all your banks at that point, and give them the power of attorney and show their identity and get registered on the account. And that can be somewhat burdensome and time-consuming. And the other thing about trusts is that they avoid probate, but they can also be very creative because you can say at what point people will receive property, what the standards are for how they'll receive property. So they can be a very, as I said, creative and protective way to pass property on to other people. So those are really the 5 key documents: power of attorney, healthcare, proxy or power of attorney, medical directive, will, and revocable trust.
Great. So I think you may have answered this, but it's a question from Susan, the person who's not able to be here today. So I'm going to just ask her question. Maybe you can just reiterate or clarify it again. So is a revocable trust necessary to avoid probate if the individual names an heir on all bank and like Fidelity accounts? Why else would one need such a trust?
Yeah, I mean, that is kind of what we're discussing. So I think the reasons, there are a few reasons. So certainly naming somebody on those accounts avoids probate, but doesn't help in terms of your incapacity. The other good thing about a trust is, say you name your son as the beneficiary on an account, and he happens to die before you or become disabled, and it no longer makes, and you don't get around to changing the beneficiary. We often see this in life insurance policies. If the property's in the trust instead, the trust will have been drafted to account for these kinds of contingencies.
Great. So I have a couple of questions, one from Sarah and also from this Susan too, of if somebody's a solo ager, i.e. aging alone without children, what advice would you give for solo agers in terms of these estate planning and these documents and all? Are there any special considerations for people who, don't necessarily have, solo agers, some might even be single by choice or life circumstances, and or could have a partner, but maybe no children, no grandchildren, no heirs. So
right. So that can be difficult. I think it's another good use of a revocable trust because you can have a professional trustee who can help. So whether that's a trust company or a bank or a trusted lawyer, they can act as a co-trustee with you or a successor trustee and step in when the time is needed. Some lawyers are also willing to serve on powers of attorney. The hardest part is really the healthcare side, because most professionals, while they may feel comfortable managing money and dealing with that's the kind of thing they do, they may not feel comfortable making more personal healthcare decisions or spending the time that would be necessary when the time comes talking to doctors and medical people. So that gets really hard. So there may be community groups that offer some help. So there are some things, different parts of the country patterned after the Beacon Hill Village, where seniors get together to share resources, and sometimes they offer kind of communal healthcare agent services. Some churches and other religious organizations do that as well. So it takes some work to put that together. I've heard people talking about getting groups of solo seniors together to offer these services to one another, but I actually haven't seen it happening yet. So I would say on the financial side, there's a solution, and then on the healthcare side, it really depends on the community.
Help. I hadn't even thought about the village model as one. I have seen, some community-based, or I know the Transition Network has a caring collaborative kind of thing and people in different areas have set something up where it seems to me that could be a vehicle for people, kind of helping each other out and maybe becoming available for, some of these roles. Tied in with the single and no parent, again, Susan has asked, if a person is single with no dependents, does owning one's home versus renting open more options for remaining in the home to receive incapacity care? Or does it offer other advantages that increase different options for care if you become incapacitated?
Well, every situation is different, so it's a little hard to say. But I think certainly owning the place gives you, in a way, more permanence there, so more likely that you'll be able to stay. You can get a reverse mortgage if you need money and you don't have money other than what's in the home to pay for it. So that can be a benefit. On the other hand, if you have the same net worth and it's all liquid and you're renting, it may be easier to access it, pay for care. So I guess it's a hard question to answer in the abstract.
Mm-hmm. Yeah, no, it's true. It's just sort of very unique to situations. I'm just sort of integrating a few of the other questions from the listeners right now. Diane from North Carolina says, wondering where to originate estate documents if you live in two different states. I know in her situation, she's part of the time in North Carolina, part of the time in Massachusetts. So how do people make those, decisions on, and how does it impact of where you do your estate documents?
Mm-hmm. So if you're spending more time in a particular place, certainly that would be the place. If it's about 50-50, it gets harder. But I would sort of pick one place as your domicile, and the place where you vote is probably the kind of the key issue. Is if that's your domicile, and do your planning there. I suppose the argument on the other side, say let's go to use Massachusetts and North Carolina. Let's say you lived in Massachusetts but are retired, and you buy a place in North Carolina and you spend the winter there, and you come back up to Massachusetts in the summer. I think one question is, where are your kids if you have them? Because there's a good chance that if ultimately you're going to need care, you're going to end up near where your kids are, and you might want to have your plan there, because that's where there's a good chance you'll end up. But then another factor, of course, is I know Massachusetts has an estate tax with the lowest threshold for estate taxes in the country of $1 million. And North Carolina, I'm not sure if they have an estate tax, to be honest, but certainly if they do, it's a higher threshold. So you may want to establish your domicile in North Carolina to save in taxes when you pass away. But that said, I've always said that the tax tail should never wag the white dog. I mean, that you should live the life you want and not have the taxes changed. But if the life you want is 50-50, then you may say, well, then I'll establish my domicile where there wouldn't be any taxes.
That's interesting. Sharon from Albuquerque asks a question about the revocable trust. She wonders, do trust companies have a minimum amount of assets that a client has to have to be eligible?
Yes.
To have a revocable trust? Yeah.
Yeah, so it depends on the trust company, and there's a pretty big range. So some, I would say, probably go as low as about $250,000, which might not seem low to everybody. And there are some that are only for the wealthy that may have required that it be over, say, $5 million. But most, I would say, have a lower limit of either $500,000 or $1 million, somewhere in that range. Okay.
So what's the biggest mistake that most people make in their post-retirement planning?
So I say sort of not reviewing their plans,
right.
but I think the other thing is the fact that there's, in a way, two stages to post-retirement. So there's the period where hopefully you're still quite healthy and vibrant and able to do a lot of things and travel and live pretty much like it was while you were working, and which is great. But the problem is that the people plan for that, but then there's a strong possibility that later on, in 10, 20 years later, that you're going to have some incapacity, and people don't plan for the second part, I think. And I think what you noted, Dory, that the oldest baby boomers are now just turning 75, I think is significant, because I think 75 is a good time to take another look at your estate plan and think about the second post-retirement stage, because presumably, hopefully by then you'll still be healthy and able to make decisions and to make any changes. And I think it's a good time to think about where you would want to be if you did become disabled and how you would get care, and maybe a good time to make a final move. So to be in a housing situation that's on one floor. If you have children who might be able to care for you, to make sure you're really close to them, because it's a lot easier for them to help out in their as part of their daily activities if you're a 5-10 minute drive than if you're a 5 or 10 hour drive away. And so I think age 75 is a really good time to take another look and do planning for the second post-retirement stage.
That's really helpful to distinguish, sort of looking at both kind of stages. It's sort of like thinking about the kind of continuum of care and preparation that we need. Because it is true. It's hard sometimes to think about the end stage, which whenever that might be, death, but it's also incapacity.
Right.
That's really difficult to think about. But the reality is the longer we live, the likelihood one or another in a relationship or, any one of us, alone or in a relationship might become incapacitated.
Right. And the closer you are to when that could happen. And
right.
And I think it wasn't until recently someone suggested 75 as being a good age for that second look, which I think is very helpful, because I guess I've always been aware that there are these two sort of stages to aging, but never had a formal idea for that about when you look at the second stage.
Mm-hmm. So Sarah from California had another question, which is, could you talk about what happens when you don't do the estate planning and the courts have to take over when you're incapacitated?
Yeah, that's another good question. So we do have a system in the country, and it's called guardianship or conservatorship. And different states use the term somewhat differently, but predominantly, guardianship is the appointment of someone to make personal and healthcare decisions for you. So it's to some extent akin to a healthcare proxy or healthcare power of attorney. And conservatorship is appointed to somebody who can make legal and financial decisions for you, and so somewhat akin to a durable power of attorney. And the process is more or less the same in all states, that if you don't have anyone else in place to handle your affairs, somebody can go to court and ask either that they be appointed as your guardian or conservator, or that if the person who's petitioning isn't really appropriate for that purpose, but it could be that a nursing home might petition, that they appoint somebody, an independent third party. And in order to file the petition, you generally have to have a certificate from a doctor that says that you're incapacitated, such that you can't make decisions on your own. And there's a process where a petition is filed, all next of kin are given notice, and then there's a date by which they need to file objection if they want to object. And then everybody goes back to court to get appointed to have a hearing. And if no one's objecting, it's a pretty much pro forma. But if anyone objects, then it can become a pretty drawn out process, because it's really litigation in a trial about the two issues. One issue is, do you need somebody appointed? And then the second issue is, who's appropriate to be appointed? So if there's disagreement, it can be a pretty expensive and time-consuming process. And if there is disagreement, then very often the court will appoint a temporary guardian or conservator to step in while the permanent one is being litigated. And then once the person's appointed, their involvement with the court is not over. So some decisions they can make on their own, and some they need to go back to court for approval of a decision. And that differs a lot from state to state. So for instance, some states may require court approval for placement in a nursing home. In our state, we have a long process for court approval if the ward, the particular protected person, as they call them now, needs antipsychotic medications. We have a whole procedure for going back to court And the conservator, who the person, or in some states the guardian, but most states the conservator who makes financial decisions, has to file what's called an inventory with the court, which is a list of all of your assets, and then annual accounts that record what money has come in and what money has been dispersed, and this whole process for getting the account reviewed and approved by the court. And for certain activities, they may need court approval. For instance, to sell real estate or to make gifts or to do any kind of estate planning, they would probably have to go back to court and get approval. So as you can see, there's a lot of back and forth with the court, which takes time, both in terms of delay, but also just sometimes time in terms of what the guardian or conservator has to do, and also costs money, because generally you'll hire a lawyer to help you with all this. So again, there's a process, and if you don't have anyone to appoint on a healthcare proxy or attorney, there may be no other alternative. The other thing I should add is that some states have public guardians who can, so they're either nonprofit agencies or quasi-public agencies that will step in when you don't have anybody else available to fill these roles. But that depends on the state.
Very helpful. So, well, there's a comment from Maria, who lives in the UK, and she says it's very difficult to explain to one adult child that you're appointing another child because they have the skills and time to, take on whatever role you're assigning to them. Can you speak to that at all? I would assume you've probably seen some of the messy situations that can happen with families.
Yeah. No, that is difficult, and I'm not sure there's any way around it. I guess one thing I would say is, well, appointing someone is, I suppose, is an honor because it shows your trust in them. It's also a burden because it means that they're going to have to do all the work. So that to explain that might help. Some people don't explain it because they just say, well, hopefully I'm going to appoint Sarah because I know that she's responsible, and not Joe because I know he's not, but I'm not going to say anything to Joe, and if it's ever needed, he'll find out at that point and be pissed off at me. But if you can explain it ahead of time, it's certainly better because transparency always helps. And it's probably better that Joe's mad at you rather than mad at Sarah, if possible, in reality. But I guess I just say that you're more comfortable with Sarah handling this in that case. And now sometimes it helps if Sarah lives close to you. Come up with other reasons, and Joe lives far away. They don't want somebody who's close, or if Joe's working 24/7 for his job and Sarah isn't. Of course, maybe the other way around. The Sarah's the one working 24/7. But if you can come up with another explanation that backs up the reasoning, that might help.
Good point with that, too. So what steps, I know one of your specialties is special needs and all, but also just in general, what steps can people take to protect children or grandchildren from financial challenges?
So something that we really like is what we call a family protection trust. So you can, rather than leaving funds outright to a child or a grandchild, you can leave funds in trust for them. And under the law in every state, if the trust is properly drafted, the funds in that trust will be protected should the child or grandchild get sued, go into bankruptcy, or get divorced. Or if they pass away, the funds will stay in trust for their children. So the trust provides a lot of protection, and the way it works is that you can create this trust for your children or grandchildren, but if they inherit the money, and they can't create the trust for themselves for the most part. So the distinction is between we often call third-party trust, where one person creates and funds the trust for somebody else, and self-settled trust, where you create a trust for your own benefit. So these third-party trusts are just a nice estate planning device for this purpose, but there are trade-offs. So first of all, things are in trust rather than outright. So the person who's the beneficiary doesn't have the same control over the asset. The trust, in order to provide the protections from divorce and from creditors, has to have some limitations on what the beneficiary can do for it. There's some more administrative costs because the trust at the point of your death becomes irrevocable. And when it's irrevocable, it has to get its own tax identification number and file a tax return each year. returns. Mm-hmm. It can be a pretty simple tax return, but it still has to do that. It's on what's called a 1041 form. So there's that burden. And for the trust to provide the most protection and the most flexibility, it's best to have an independent trustee. So if you have a trust company or bank as the trustee, you have that extra cost. So those are the drawbacks. The way we usually draft them in our practice is we do allow the child to be trustee of his or her own trust, but not to take principal out. So they could still manage the assets. If it's a house, they could still live in the house. They could still take the income each year on whatever is invested. But if they needed to dip into principal, at that point, they would have to appoint an independent trustee. So we're trying to sort of thread the needle by making it not so burdensome that people don't want to use them, but to have enough restrictions in place to provide the protection for which it's intended.
Great. So what legal steps should you take if you enter into a second marriage or a committed relationship?
Another great question. You're getting a lot of good questions. So the most important thing I would say is to write down an agreement with your partner. So it can be a formal prenuptial agreement or not, but you should talk about who's going to pay for what you consider your obligations to be. If somebody becomes disabled, what's going to happen to your assets? Are they going to be pooled and ultimately shared among all of your children or be kept separate? I think writing it down is really important for a number of reasons. First, it makes sure you're on the same page. Because if you don't write down, you may just assume that you're on the same page, and you're not. So if you write it down, it'll force the discussion. Writing things down always brings up issues you didn't think of ahead of time. So you may only think of 3 things you got to talk about, and you start writing it down, and you just think of 3 more. And so I think that's important. Third is an aid to memory. We all I think finally know that memory is not so great. I'm not talking about dementia. I'm just saying our memories of what happened are in the past are not accurate. So you may be surprised 10 years later that you agreed to something because in your mind you thought it was something else. So I think that's very important. And then finally, those pesky kids might be shut up by seeing it in writing. So they may think you ought to have done something different than you and your partner agreed to, or that you did do something different, and these 2 families can end up getting into fights. But if it's in writing and it's clear that mom agreed to X or Y, even though you think it's a bad idea, you may not argue about it since mom did agree to it. And then the question is, well, can you do this yourself, or do you need a lawyer to do this? And that's really a question of how formal you want to be about it. But I'd start, even if you were to go to a lawyer, the more you can do yourself, the better prepared you'll be when you do see the lawyer.
Excellent. And the other thing that comes to my mind when you say that is, often there's anxiety that gets triggered when people are talking about money. We say money, sex, and death are the hard things to talk about. And when there's anxiety and you're, in a new relationship or something, it can affect also our thinking. And that's so I just think it's the idea of writing things down is so important because, just at the moment, anxiety may get in the way of sort of thinking about some of the things that are important to you that you want, to consider with this new partner. So I just think it's, there's also a psychological kind of benefit of writing it down and looking at those lists. And what you were saying before lends itself to another question that Sarah from California asked, which can you talk about the importance of sharing your estate plans with those who are named in them? I mean, what's your advice in relation to that?
I think the more you can share, the better. I mean, every situation is different, so there may be instances where it doesn't make sense. But I think it's important just to let people know what the plan is so that they're comfortable with it. I think it's important for them to have some idea of what your estate is so they don't have misconceptions about how big it is. I would run into trouble. I think of one case in particular where some children thought their dad's estate was much bigger than it was and thought that this was a case of a second relationship and thought their that mom was stealing from them when she wasn't. So if they had really known, that might have helped. So I think, and then maybe the kids just don't want to bother with it because they're busy with their own lives and raising their kids. But if you can send them PDFs or whatever your plan is, at least they know that they have it and that they can look at it if they want to, and they have it, can save it away for when they do need it. And if they know who your lawyer is and who to contact, that's also very helpful. And just offering, say, look, I'm happy to talk about this, or I'm happy to have you talk to the lawyer about it, why we did it this way. Even if they don't take you up on it, I think just the act of doing that, I think, can relieve stress. And especially in a second marriage where there may be real concern about what's going to happen to an inheritance.
Right. Yeah, I totally agree. I've read somewhere, a comment of, you don't give people, keys to the car without them knowing how to drive. And in the same way, it's sort of that idea of the transparency. If possible, you want to talk ahead of time with people if they are going to inherit money, to be able to be responsible and think about it ahead of time. And it's a really wonderful intergenerational conversation that could happen if, you can allow yourself to do it. And it could help somebody be more prepared that it will be there down the road.
That's actually happening in our family right now to some extent because my mother has decided to update her estate plan, and it's decided that neither of her sons need anything from her, and her grandchildren might. And there's at least one grandchild, my daughter, who thinks she should give everything away. So she's pushing her to be more charitable. So,
well, it's a great example. So, yeah, it's good to talk about it ahead. Yeah. So I want to shift to another part of this, and there are a number of questions here on it also that I will ask. But at what age should you think about long-term planning, and what's your sense of the pros and cons of it?
So
tied into it is one. Let me throw out this other question that goes with it, which is Charles from Boston says he read that anyone with assets greater than $2 million may consider not having long-term care as their assets should be sufficient. Is that true? So I just want to throw that out also as you're talking about long-term care.
So more good question. So we're really talking about long-term care insurance, I think, because long-term care planning can include Medicaid planning as well.
Yeah.
But I'd say probably in your 50s if you're thinking about long-term care insurance, because if you start then, it's just going to be more affordable. And then if you wait to your 60s, and then especially if you wait to your late 60s or 70s, it's probably going to be unaffordable. So I'd probably say your mid-50s is a good time for that. And depending on where you are and how your life went, that might be a time when you can might be better afford the extra expense if the kids are grown and out of college and you have some more disposable income and are still working. It may be more affordable. And hopefully you're still in good health. Because what happens after 60 is things start happening. So that might be harder to get the insurance or just maybe more expensive. But the other question is, unfortunately, it's expensive. It's more expensive than it used to be because they know the underwriters know more about the use of the insurance. And the good news is the insurance policies are better. There were some fly-by-night insurance companies that used to offer insurance at relatively low rates and then not necessarily pay out when you needed it. So we've had some cases in our office where we've had to threaten litigation to get clients paid, get them the benefits that they were entitled to. But you have this, so it's expensive, which means to some extent the people who can afford it also might be the people who can self-insure. So the question about at what level of your assets do you not need it? And certainly if you have a couple $1 million in investable assets, you probably don't need it. But would you want it anyway is a question. And the reason you might want it anyway, I think has to do with psychology to some extent. So the geriatric care managers have told me this, that people are reluctant to spend money on care. So you often see one spouse killing himself or herself, taking care of another spouse, when they probably could afford to dig into their savings to pay for care, but they won't. And it's hard to do that. They have those savings because they've been saving for decades. And even though this is the rainy day that they've been saving for, it can be hard to do that. But if the care would be covered by insurance, they're happy to spend the insurance money because that's like free money. So I'd say even people with $2 million investable assets might want to consider it. And but it's a hard question. I think it's very much a gray area. It depends really on what you would feel more comfortable with it. And the problem is with people with less money who have probably more need of the insurance, they probably have less ability to pay for it. That's the problem with our whole system.
Yeah, that's the part of the quandary. I have some other questions of that in a bit too, but I think I want to ask about the pros and cons of Medicaid planning, because I think that becomes an important area too, and I want you to speak to that before we hit the top of the hour. And I know some people probably have to leave right at the top of the hour, even though we can go over a little bit longer.
Yeah.
So what about the pros and cons of Medicaid planning?
So there are two kinds of Medicaid planning. So one is advanced planning and the other is crisis planning. Mm-hmm. So advanced planning really means giving away your assets. Now you can give it away entirely, you give it to someone else and they basically got their inheritance early, or you can put it into an irrevocable trust. But even when you put it in an irrevocable trust, you've given it away, so you can no longer take the asset out of the trust. But you can retain some benefits. So if you put a house in a trust, you can still live in the house. If you put investments or rental property in the trust, you can still get the income from it, even though you can't take the principal out. And under the Medicaid rules, when what they call countable assets are under $2,000 in most states, and your spouse, if you're married, his or her so-called countable assets are under $130,000, then you can get Medicaid coverage of your nursing home care and in some instances of home care or assisted living care. Those are kind of the basic rules. And if you give away assets, you're not allowed to get Medicaid coverage for 5 years. So that's why you do things in advance. So if you give it away or if you put it in trust in a way that's sheltered, and you do that 5 years before you need care, then you can get Medicaid to pay for your care. And so that's whether you want to do that really depends on a lot of factors. Are you more concerned about saving these assets for your children than having them available to pay for your care and to give you more flexibility in paying for your care? And that's a judgment call that each person has to make. So that's advanced planning for qualifying for Medicaid. But crisis planning is when you do need care and you need some way to pay for it. And at that point, well, if you have a lot of funds, you may say, okay, well, I'll pay for up to 5 years, and I'll keep that amount to give the rest away. And most people don't need care for 5 years, but some do. But that's an approach. But there's a lot of ways to protect assets for a spouse, and through trusts and through reserve assets and through purchasing annuities. And so after the fact, there's probably a lot you can do to protect assets for Medicaid purposes. And probably the most important thing to have in place to be able to take advantage of those opportunities is a durable power of attorney. That's another reason to have that in place.
So how would a durable power of attorney step in? I mean, how would that be used to help during that crisis time?
So a significant part of what you may need to do is transfer assets from one spouse to another. Uh-huh. So you need to have, and you need to do it when one spouse is incapacitated and can no longer do it himself or herself. So the other spouse or another family member needs to be able to make the transfer. So you want to transfer the house into the healthy spouse's name, and you probably want to transfer other assets into the healthy spouse's name so that then he or she can annuitize them.
So back to this pros and cons of Medicaid planning, there was a question from Susan, the person who's not here, and just, I mean, in a sense, I think you've answered part of it in terms of really thinking ahead to try to protect one's assets. But because, she talks about, if you don't qualify for Medicaid, but you don't have really enough money, what are ways that you could benefit from some, financial help? And I think you're saying that, that I think what I'm hearing is that the advanced planning of just trying to protect your assets. And this is somebody who also asks questions of being a solo ager. So there's not like you can protect things with a spouse or something. But so any other means? I mean, you mentioned annuities. You mentioned, could you talk a little about those vehicles? Because I know, or reverse mortgage, we hear about those things, and I always hear pros and cons. So I'd love to hear your viewpoints on things like that.
Yeah, well, everything has pros and cons. So all these are tools and mechanisms that can be useful in the right circumstances and detrimental if used in the wrong circumstances. So annuities I talked about used to protect a spouse are a certain kind of immediate annuity, but there are a lot of annuities sold on the market that are not immediate annuities and they're really an investment vehicle. And some of them have features that are useful for financial purposes, but they're incredibly complicated and are expensive in a lot of ways. So are probably for most people are not advisable. But those are the kinds of things that a financial planner can really advise you on better than a lawyer. So that was annuities. Reverse mortgages also can be somewhat expensive. They're highly regulated, so I think they're less expensive than they used to be. And I always think of them as kind of the tool you use as a last resort when you've used up all your other funds and you need to dig into the equity in your home. Then the reverse mortgage can make a lot of sense. So I wouldn't use it just if you can avoid it. I wouldn't use them for just living expenses. So I guess if that's your only choice, maybe that's the one you have to make. But they can be very useful for when your expenses, if you have enough money to live on but not enough money to pay for care, when you start needing care, that might be a really good time to dig into the equity in your house.
So that maybe also is a thing about owning versus renting, that if you own, you have some equity in your house and could think about that, using that. Good. A question from Diane, who lives in Campbell. What happens to property if a couple's divorced, but both names are on the deed and both live on the property, and then one of the spouse dies?
So that depends on state law. So most couples own property as tenants by entirety, which is kind of joint ownership where it passes to the surviving owner. But on divorce, they may become tenants in common, and where they, in effect, each own half the property. So in that case, if one of them dies, his or her half share goes to his or her probate estate and then gets distributed according to his or her will. So that can get complicated. So it may be a good, depending on what they want, it may be a good place to use a trust, because the trust might say that it's for the benefit of both spouses and that the surviving spouse can continue to live there. But when the surviving spouse dies, everything gets distributed equally. Now, again, if they have the same children before they got divorced, maybe it doesn't matter as much. But if they have different sets of children, it can be even more important.
More complicated,
And even more important that you provide for what happens. Because we've seen a lot of cases in second marriages where there hasn't been planning or hasn't been good planning, and where the assets of both spouses ends up just depends on chance. Whichever spouse lives longest, his family gets everything, and which is probably not what anyone ever intended.
Right. It does talk about the being intentional and conscious of taking care of these things. I have a couple more questions, since you said you had a little bit more time. One of the other things I love about your book is you talk about pets as being parts of family, and also trust for pets. Can you speak a little about that?
Yeah, it's always a relatively new phenomenon that every state now allows you to create a trust for your pet. So you can set money aside and name someone as trustee to manage the funds for your pet. You could always name who will be the guardian or owner of the pet in your will, and you want to make sure they have enough money to do whatever they need to do to take care of the pet. So you can do it through a pet trust. You could also just give them the money, just assume without the formality of a trust, but give them money and kind of understand that this will be, if you trust them to do the right thing to take care of your pet and to maybe a little bit of compensation for doing so, to the extent they don't need the money for vet bills. But I think planning for your pet, especially, I think most families figure, somebody in the family is going to, first, most people figure they're going to outlive their pets, and then if that doesn't happen, that the family will step in But if you don't have family to step in, and especially if you're single, I mean, I think if you don't have children, the pets, I think, become all the more important to you. It's really important that you do planning for them.
Great. Also, well, there's another question here from Beth from Minneapolis. What if someone hires an attorney from a different state from where they live? What are the pros and cons of that?
Probably more cons than pro. Just because they're less likely to know of anything peculiar about your particular state in terms of its laws. So it's always, you don't know what you don't know if you're in a different state. So I'd be more inclined to hire an attorney in your state.
Helpful. And what about, I mean, you mentioned a couple of times that, sometimes one could benefit from having an attorney, and sometimes there's some documents or things you can do yourself. So how does one go about finding an attorney or deciding, kind of on the do-it-yourself approach?
So I'd say that the forms provided by LegalZoom and a number of other sites out there, there's something called willing.com, are probably going to be really good forms. I mean, because they can hire the best attorneys to draft their forms. And so why would you use an attorney rather than using one of these online systems that are so much cheaper? And probably two reasons, or at least two. One is the ability to ask questions and get answers. So now one thing that I know LegalZoom does have a very inexpensive system or service where you can ask questions of attorneys, but they don't, as I understand it, you can ask questions, but the attorney doesn't then draft the form or review what you've drafted, so they somehow keep that separate. So you still have to deal with the form. So you don't have that. You don't make sure it all kind of comes together. So I think that's a drawback of the form system, just that if you have any questions or if anything's at all complicated, the form system is less likely to work. The other thing is working with attorneys are more likely to get it done. My guess is that a lot of people say, well, I got to do my estate plan, and they start the program, and then they get into a question, well, who should I appoint as guardian for my kid? And, I better ask my cousin John, and they stop, and they may or may not get around to asking their cousin John, and then they never get it done. And I think with a lawyer, hopefully they're going to be, especially if the lawyer's not paid until you've completed the work, that they're incentivized to keep after you to get it done. So
the accountability piece.
Right. So I think the ability to answer questions, the ability to respond to unusual situations, and the accountability to get it done are all reasons to use an attorney. Now, the second question is, how do you find the attorney? Right. And I think the best approach is word of mouth. Ask people whether it's friends, family, or other professionals, an accountant, a financial planner, who they would recommend, because these are people who have worked with the attorney, so know whether the attorney is responsive, whether they have a good bedside manner and answer questions, and whether they get the work done, and whether they feel like they charge reasonable fees. So I think that's the first place. You can also search online and get an idea from websites of information about attorneys. You can do that either to check up on the names you've received, or to start with. If you need an attorney in a specialty, there are some organizations where it's worth checking the website. So if it's an elder law attorney, you may want to look at the National Academy of Elder Law Attorneys or elderlawanswers.com, which is actually my website, but we have a lot of attorneys listed. If it's special needs planning, there are two organizations. One, again, that I helped found called, when the website the organization is called the Academy of Special Needs Planners, and the website is specialneedsanswers.com. There's another organization called the Special Needs Alliance, which also has a lot of really good special needs planners. And then if you're looking for more high-end planning, if you have a taxable estate, you might want to look at ACTEC, the American College of Trust and Estates Council, at actec.org. And that's a good organization because, unlike all the other ones I mentioned where really any attorney can join, Act Tech, you have to have been nominated and approved by your peers. But again, that's going to be mostly people who do more higher-end estate planning.
Mm-hmm. Great resources. And I know you mentioned, these resources also in the book. This has just been so terrific, Harry. Thank you so much for being with us today. And
well, thank you. Thank you, Dora. You seem to have an audience with really good questions.
Yeah, no, it's a combination of general public and professionals. And, I think everybody is pretty much in this boomers or beyond age group. So I just want to say again, the book, Harry's book, is Get Your Ducks in a Row, The Baby Boomer's Guide to Estate Planning. And Harry, do you want to mention again, I can mention it, I guess, the Ask Harry, but why don't you just mention again about that and your website and then a final takeaway that you'd like to leave us with.
Yeah, so thanks, Dory. So my website, askharry.info, I just answer questions on it and then post them, the questions and the answers, and I also put a lot of pieces of the book up there as well. So there's just a lot of information on estate planning on the site. The hope is that ultimately, as it grows, that any question you may have, you'll be able to find the answer there. And if you don't, just ask me, and I'll do my best to answer it. And so that's, I guess, the place to go. And if you have questions, a place to post them. And the takeaway is really to plan. And estate planning is for life as well as for death. And so make sure you have a plan in place and share it with your loved ones.
Great. Thank you so much for taking the time to be with us and share your perspective and wisdom and expertise. I really appreciate it, and I thank everybody who has been part of the call. So stay well and safe. Well, thanks again,
Thank you, Dory.
Harry. Take care. Bye-bye.
You've been listening to Revolutionize Your Retirement Radio with Dr. Dorian Mintzer. To learn more about the resources mentioned on today's show, listen to past episodes, or download our free retirement transition guide, visit revolutionizeyourretirementradio.com.